Judicial review, or JR, is, the mechanism through which courts supervise the lawfulness of public body decisions. The applicant, whose housing request was rejected by the CHA, may challenge that decision through JR, but only if certain strict procedural and substantive criteria are met. First, let's talk about public bodies and whether they're amenable to JR. The Council Housing Association, or CHA, was created by a bylaw under the Fictitious Act, so it exercises public functions, especially when allocating housing based on statutory duties. This basically satisfies the requirement that the decision be public in nature. The Aga Khan case is sometimes contrasted, but here the CHA is acting under legal authority. Next, standing, or locus standi. The applicant clearly has sufficient interest in the matter as established in RV Inland Revenue Commissioner's ex parte National Federation of Self-Employed, since he is directly affected by the rejection of his housing application. All right, let's talk about time limits. Under CPR Part 54.5, judicial review must be brought promptly and, in any case, within 3 months of the decision. In this example, the decision was made in mid-March, but the applicant only read the email in May. However, time runs from the date of the decision, not when the applicant became aware of it, as established in the case of RV Secretary of State ex parte Osler. So unless there are exceptional circumstances, the deadline would be mid-June. If applying late, the applicant must ask for permission for an extension and show good reason. Just delaying reading the email usually isn't enough unless it's linked to incapacity or a genuine lack of access. Before seeking judicial review, the applicant must exhaust any internal remedies like appeals within the CHA process. They also need to send a letter before claim which outlines the challenge and gives the CHA a chance to respond. There are several grounds that might be argued here. First, bias, which is a type of procedural impropriety. If the CHA member handling the case has a personal interest or any known hostility toward the applicant, that breaches natural justice. A fair-minded and informed observer must not suspect bias, as set out in the Porter v. McGill case. Next, there's irrationality, often referred to as Wensbury unreasonableness. For example, if the CHA refused the application solely because the applicant could move in with their parents, while ignoring other serious needs, the decision might be considered unreasonable. There's also failure to consider relevant factors or misuse of discretion. The CHA has a duty to consider housing need, and disregarding the applicant's circumstances in favor of rigid rules can amount to illegality, as seen in the Fewings case. Finally, if the rejection email does not provide a proper explanation that could breach the duty to give reasons, especially where the decision affects fundamental rights or livelihood, as in the Cunningham case. So, subject to meeting the procedural conditions, especially the time limit, the applicant actually has a strong arguable case, particularly on the grounds of bias and maybe unreasonableness. If successful, the court may quash the decision and require the CHA to reconsider it lawfully.